Hello and welcome to the Daily Aus. I'm Sam Koslowski.
I'm Zara Seidler.
It's Monday, and that is the most popular day of the week for workers around Australia to chuck a sickie. You might actually be listening to this as you're in the process of chucking a sickie right now. And we've all heard it before, chucking a sickie is a bit of an Australian tradition. But last week, the Fair Work Commission ruled against a Melbourne lawyer who was fired after chucking a sickie to attend the AFL Gather Round in Adelaide last year. The case has sparked a national conversation about sick leave, when it's appropriate to use it, and what rights employers actually have if they suspect an employee is lying about needing to take a day off.
Sam, never before in the history of the podcast has chuck a sickie been said so many, probably ever been said before, but then secondary to that, said so many times.
I need to focus on not making it sound like one word.
Yeah. I don't know if you've succeeded at that.
Sickie.
Anyway, this is a very wild story. It's one that has invigorated the office like very few stories do. I believe the last time this happened was about the scientific discovery pertaining to a snake. This is not what today is about. Today is about actually a legal standard that has now been set. So take us back to the beginning. Why are we talking about chucking a sickie?
Okay, so let me tell you about a Melbourne lawyer named Mitchell Fuller. Mm-hmm. Now, in April last year, he called in sick on a Friday to his law firm, and he told his employer that he had a tough time sleeping and that he wasn't feeling up to coming into the office. Then, on the following Monday, he sent another email saying he was still in a bit of discomfort and couldn't, quote, hack taking public transport. He even obtained a medical certificate for that day from an online provider. But in reality, Fuller had flown to Adelaide on the Thursday night to watch the AFL Gather Round, which is the annual round where all AFL teams play in the same city. It's a bit of a festival of football. It actually just happened this weekend, so it's interesting timing for this story.
Look at that timeliness. That's why we're doing it today. You knew this all along.
Yeah, I'm actually recording this from Gather Round. No, I'm here. Over that weekend, he attended a number of football games. He went to the beach. He spent time at the pub, all of which he later posted about on Instagram.
There's so much there.
Mistake number one.
I don't know really where to start with that one, but I am guessing that his employer found out.
Yes, the top secret sickie mission actually went undetected for about 3 months though, so he had a good run. Fast forward now to July of last year, and the law firm that Fuller worked at engaged an HR consultant to help with unrelated performance issues that Fuller was experiencing. That consultant then checked Fuller's social media, connected some dots, and figured out that Fuller had indeed chucked a sickie.
Imagine thinking you'd gotten away with it, only to learn 3 months later that in fact you have not.
Because I imagine there would have been probably 10 to 12 weeks of anxiety there that you were going to be discovered, and that was probably over the crest.
Yeah,
that was probably the safe zone.
Okay, and so it was found out that he was at the AFL Gather Round.
Yep.
He was not sick at home in bed.
No.
So what happened then?
So he was fired. So the workplace confronted him about the posts. They gave him a chance to respond. And after the response, the law firm terminated his employment. And that takes us to August of last year. Now, in his defense, Fuller argued that he believed he was entitled to take what he called a mental health day as part of his sick leave entitlements. That all led to him filing an unfair dismissal claim with the Fair Work Commission, and that's why we're talking about it today. We have that judgment now.
Okay, so before we get to the judgment, I am keen to just unpack a little bit more about what Fuller actually said when he was defending himself before the Fair Work Commission. You mentioned their mental health days, something that, we hear and we talk a lot about as employers. I'm really keen to understand his argument here.
So basically, he kind of laid out 3 core arguments.
Yeah.
On the first argument, he said he actually was unwell on those days. He told the commission that he has ADHD and there had been a nationwide shortage of his medication. Secondly, he argued that taking personal leave for a mental health day shouldn't be considered misconduct. He said that feeling stressed or anxious about work did justify using his sick leave entitlements. And then finally, he claimed that the actual dismissal process run by the law firm wasn't fair. He wasn't given an opportunity to properly respond to the allegations, and therefore that was enough for the unfair dismissal. When you take all of that together, he basically was saying, I was sick because I'm entitled to it, and he didn't give me a chance to respond.
Yeah. Fascinating. And so obviously we led at the top with the fact that the Fair Work Commission didn't agree, didn't accept those arguments. Talk me through the ruling.
So the Commission ultimately ruled that the dismissal from the law firm was totally justified. They found that Fuller had knowingly made false statements to his employer in emails and had wrongly claimed paid sick leave when he wasn't entitled to it. Now, I think one of the things that's interesting and particularly related to this case is that his actual job formed part of the reasoning. He was a lawyer, and lawyers are expected to tell the truth and to be upstanding citizens who we entrust with operating our legal system.
Yeah, interesting.
And the ruling stated that Fuller's conduct was, quote, utterly incompatible with his ongoing employment as a solicitor, where integrity and honesty are paramount. And what I found interesting about that point is this common thread I discovered in learning more about the Fair Work Commission, that every case really is quite different. And there are kind of these core principles that go across them, but it really is about the individual, the worker, the circumstances. Another thing I found really interesting was the Commission found that simply feeling you'd be better off after having a day off work is different to being unfit for work because of an illness and a mental health illness. And that's actually the requirement under the Fair Work Act for taking paid personal leave.
Well, I mean, it is interesting because, so for example, with our business, when people go in to put leave on Xero, which is how we log our leave applications, and it's a platform that hundreds of millions of businesses around the world use, you actually can't distinguish your sick leave from, say, mental health leave.
Right. It's all
all your personal leave. And so it's really interesting that we're now breaking down and distinguishing why and how you can use each of those different kind of leave applications.
But also we're talking here about what does a mental health day actually mean?
Yeah.
And there was this really interesting part of the judgment where the Commission basically said there are not many people whose outlook on life, health or work wouldn't be improved by taking a paid day off and spending it with friends. But that does
Couldn't agree more.
Yeah, but that doesn't elevate those circumstances to unfit for work because of an illness or injury. And what we're talking there about the definition of a sick day in the Fair Work Act, which is that you need a day because you can't work because of personal illness or injury. And so the Commission was differentiating between, obviously we all feel better with the day off, but does that mean you're entitled to a mental health day? And the answer was no. You have to be unable to work, not just reckon you'll feel a bit better.
And so if that's the rationale held by the Fair Work Commission, does that mean that your employer can always ask you for a reason for your sick leave?
Hello, Billy here from TDA. We have just looked at our YouTube analytics and 95% of you who are watching our videos aren't subscribing. If you want to help independent media like us grow, the best way you can do that is by pressing subscribe. Thank you so much, and back to the video.
Yeah, so employers are entitled to ask for evidence that gives them an understanding that you're genuinely entitled to paid sick leave. It doesn't always have to be a medical certificate. It can also be a statutory declaration, which is basically when you write a statement and you swear it's true and often get it certified by a witness. But here's another really interesting part of this case. Just getting a medical certificate might not actually be enough either. In Fuller's case, the evidence on social media of his attendance at the pub and the footy actually kind of ruled out the validity of the medical certificate. One other interesting point that I'm not sure the Commission really knows what to do with just yet is that he got the medical certificate from an online consult.
Going to ask you about that.
Yeah, and the Commission said that because the certificate was based only on what Fuller told the doctor, not a proper assessment, there was also a bit of doubt over the validity of the certificate. So there's no hard and fast rule there. Yeah. The Commission didn't say you can't get an online medical certificate, but they cast a bit of shade on it. It is super murky.
All of it is murky, and so much of it is grey here. And I think that speaks to how significant this ruling actually is. What does this ruling mean for you and I, for the team that works with us? What does it mean for employers and employees across the country?
It's a really tricky one to answer, Zara. As I mentioned before, there's this kind of unique set of individual circumstances that surround every unfair dismissal case. There's obviously minimum standards of employment and awards and all of that kind of stuff. But when you get to that level of being in front of the Commission, they look at the whole picture.
Yeah.
But ultimately, there's kind of three main things I took from this judgment. One was that you can't take sick leave when you're not sick, and it's not a good look when you deliberately deceive your employer. Two, is that social media posts can be used as valid evidence in front of the Commission for a workplace dispute. And 3, the most complicated one, while genuine mental health issues are valid reasons for a sick day, you can't just label any day as a mental health day purely because you'd feel better off after taking it.
Yeah, see, that's the point that I'm struggling to wrap my head around, because who is determining what a genuine mental health day looks like or feels like for any given person? If you've sustained a period of burnout over, say, 3 months, what then?
Well, let's bring this to the facts of the case. This case at its heart is about deception. It's not about, a genuinely trusting relationship between an employee and an employer. It's about falsely getting medical certificates when you're putting on social media that you're at a live sporting event. And so I think that it's really important not to conflate the two. And in a lot of the materials that the Fair Work Commission puts out, they're constantly referring to encouraging employees to have honest conversations with their employer. And let's think about it from you and I, from our perspective. If somebody came to us and said, I've just worked really, really hard for X amount of time, I'm feeling burnt out, I'm feeling tired, I would like to take a sick day, we'd say, of course. And so then they could go to the footy and all that kind of thing if we had a basis of a trusting relationship before that day off.
All in all, there are so many elements here that are uniquely modern. The finding out on social media, the telehealth appointment. There's a lot here that, even Fair Work will need to catch up with when it comes to modern day workplaces and employee-employer relationships. All of this is super interesting. I bet Mr. Fuller didn't think that going to those footy matches would spark a national conversation, but here we find ourselves, and no doubt the beginning of many. Sam, thank you for explaining that, and thank you for listening to another episode of the Daily Aus. We've got another big week of headlines and deep dives ahead of us, so make sure you tune in later today for that. Until then, have a great day.